Hi there, welcome back to the second part of our ITC 999 webinar series, this time on contracts and negotiations. My name is Thea, I am the Communications Manager of ITC.
And I'm Charlotte and I'm the Chief Exec of ITC.
Just to let you know, this webinar will last for about 20 minutes and then all relevant resources, so in this case it will be our sample contracts, will become available on our website to everyone. So do go and check those out once the webinar is over. Also, throughout the day, we are running offers on all training at members' rates. So we have a special ITC 999 rate. So do go and check that out as well. And please continue to tweet or email or Facebook in any questions you have regarding any topic relating to theatre management, etc., using hashtag ITC 999. So without further ado, straight into contracts and negotiations. Charlotte, can you tell me, baseline, what does a contract need to include?
Right, okay. Well, perhaps I better just tell you first what a contract is.
Oh, yes.
Because there's perhaps a popular misconception that a contract is a piece of paper. In fact, a contract is a legally binding business agreement between two or more parties involving some form of exchange. That's what a contract is. Verbal contracts can be binding. Right. The thing that we often call a contract is actually the evidence of that contract. And so the piece of paper that you're signing, which you're probably busily calling a contract, is actually the evidence of that contractual arrangement. So what it needs to include, first, obviously, thinking about that definition, it obviously needs to include details of the parties to the contract. Okay. So it's going to be, you know, if it's a limited company, if it's a contract between you, Thea, and us at ITC, it's ITC, Independent Theatre Council, and Thea Stanton. You have to get the names right to make sure that you're identifying people properly. And if it's a limited company, it's a very good idea to check their name on Companies House. And include that as well, because they might have a trading name. So you've got your parties to the contract. Then you want to include the exchange, the deal. So in very simple terms, it might be the show that you're going to be putting on and the fee that you're receiving for the show, or the venue that you're hiring and the fee that you're paying for that. The exchange is essentially the deficit to one and the benefit to the other. So,
right.
So it can be, I'll talk about that again in a minute, but it can be not necessarily the market rate. And then it needs to include all the kind of terms and conditions,
right,
which basically answer the questions, the sort of the what, the when, the how, the where, the what else. Essentially, they can be very simply expressed. There's no law that says a contract has to be partially in Latin,
right,
including terms like hereinafter and wheretofore. The simpler the better, the clearer the better. It just needs to say exactly what the deal is that you've done. And then, very importantly, I would suggest that every contract that you sign, you need to have something in there that says what happens if the contract's not properly performed. So a cancellation clause, a kind of what-if clause. Very good idea to have that. And it obviously needs to be signed and dated. Yes. And that's just sort of copper-bottomed evidence for an agreement or a contract that you've done.
And it needs to be dated, from what I understand, because chronology is quite important.
That's right. Yeah.
In contracts.
Exactly. If you change the deal that you're doing and you issue a new contract, that's going to be the one that overrides what you've done before. So if you've got previous evidence of the deal that you've done, keep it by all means, but make sure you strike it through and sort of say, you know, that's no longer the valid contract, because otherwise you're going to be looking at the wrong document. Yeah.
And in terms of issuing a contract, so I'm a choreographer and a producer as well as working at ITC, and in my experience, it's always the venue, or essentially the more powerful party, that issues the contract. And whether I agree with the terms or conditions or not, I just have to go along and kind of sign it. Is that usual? Is that correct?
It is unfortunately common that we come up against this problem, but contrary to popular opinion, anybody could issue the contract. So it shouldn't be that the larger organisation or the most powerful organisation issue the contract. In fact, our experience is that quite often venues, with no disrespect to any venues that might be watching, often have a contract drafted many decades ago by a long dead lawyer, and they're a bit afraid to change it. And so they're kind of sending that out. This is our terms and conditions, this is our standard contract, and it may well not be relevant to the deal you're doing. Essentially, what's in that contract needs to be the deal that you have done. So you want to make sure that there's nothing in there that's irrelevant to the deal that you've done, and nothing in there that overrides the deal you've done. There's no such thing as standard clauses that have to be in a contract to make it legally binding. That's a bit of a mythology.
Right.
So, I mean, I'd strongly encourage small organisations to issue their own contract, to keep it simple, keep it clear. A few years ago, we drafted a model contract for companies working in schools, touring into schools, and we deliberately created a document that was only 1 page of A4 because we recognised that teachers just could not turn over a page of A4. It was too much effort, and you needed to get that signature and signed back to you in order to do that. So yes, that's it is absolutely not the case that a venue has to issue the contract.
And even if it does so happen that the venue issues the contract, is it okay to go and negotiate?
Of course, yes, absolutely. I mean, I'm always saying to our sector, value your work. Think about what it's worth to you before you go in there. You don't have to agree to everything. You can negotiate, you can discuss terms. In fact, I think you're often more respected if you do. It's a professional business agreement. You have absolute right to discuss what you're being offered, and also to not necessarily feel intimidated or offended by what you're being offered. Yes, you will be offered, perhaps, people will chance it and try and offer you a low rate or whatever, but you can go in there and discuss it and talk about the actual cost of making that work and the actual value to you.
And is that to all types of contracts, that kind of ability to change and negotiate? Does that apply to all types of contract, or if there's an employment contract?
Essentially, yeah, you can contract on any basis you like.
Right.
That's kind of, what's a fair contract? Well, what have you agreed? But yes, you're absolutely right, Thea, that there are certain special rules that apply to employment contracts. It is the case that with contracts, although essentially the terms that you've agreed are going to be the terms of the contract, there are certain conditions in which terms can be implied into a contract.
Right.
And employment law is one of those very particular areas. There's an awful lot of statute or law, government law, that enters into the realm of employment contracts. So, for example, we now have a national minimum wage.
Yeah.
The EU working time regulations mean that there's a maximum number of hours in the working week, 48 in fact. There is the condition that you have to pay holiday pay, which amounts to roughly half a day's pay for every week worked. But there is a slightly more complicated calculation for that. You have to provide maternity leave and pay, paternity leave and pay. Pensions now.
Yeah.
So there's all sorts of terms which are implied into an employment contract. And if I wanted to engage you as an employee and offer you £5 an hour and for a 60-hour week, you would have, even if you agreed to that, employment law would intervene and make sure that you were paid the national minimum wage and that you only worked a maximum of 48 hours.
Okay.
So even if you agreed to it. That doesn't apply, of course, to freelancers. When you're talking about freelancers, that we're back to the kind of, you can be engaged on any, or you can contract on any basis you like.
Right, I see.
So that's the distinction.
Yeah. How do I tell if I'm a freelancer or an employee there?
Very good question. Well, it's all down to the relationship. It is not possible to choose, actually. You can't say, oh yes, I'm going to call this a freelance agreement. So the things that dictate whether somebody is an employee Essentially, it comes down to whether there's a master-servant relationship there. So is the person obliged to turn up to a certain place of work at a certain time? Are they obliged to carry out the work themselves, or can they delegate it to somebody else? And if all of those things are present, the chances are that they are a worker, that they have an employed status. So actors, for example, not much use if an actor takes their work home, because it's of very little benefit to the audience to say I'm carrying out this work from home, and also you're going to be expecting that actor to carry out that role. You can't suddenly decide to send along a friend to do it instead. So if you are employed, you are entitled to all of those legal protections that come with employment. And so even if you if your engagement is described as freelance, you may still be able to rely on employment protections because of that master-servant relationship.
Right. And so a good example, I suppose, of a freelance would be maybe a graphic designer I was working with on a poster or something like that. They would be able to work from home, set their hours more or less, apart from the odd meeting here and there, and I suppose delegate
somebody else. So if they suddenly couldn't do the work, they could get someone else to do it, and provided they completed the services that you contract them to do, or somebody does, provides you with the product, then so in fact, your designer on a show might well be a freelancer, but really the actors can't be. At this stage, it's probably worth mentioning that there is a sort of special status of actors in terms of tax. Back in 1993, there was a tax case, McCowan and West, which allowed actors and theatre practitioners to do their own tax, so to behave as if they were self-employed for tax purposes. It, however, retains their right to be treated as employees for contractual purposes. It does create a certain amount of confusion, but that is essentially the case, that they are still workers. Right.
And with all contracts, what if someone doesn't stick to the terms of the contract?
Sure. Well, that's what one might call breach of contract. Okay. So you are entitled to rely on the terms in the contract that you have made, or in the agreement you have made, and that's enshrined sometimes in a document, or as we said before, sometimes it might be verbal. Right. Those terms are legally binding. So if they have been broken, there are various things you can do. I mean, there are various court actions you can take. There is something called specific performance, which enables you to get a court order forcing someone to complete that contract. That might happen in a building contract most commonly. So if you're having your theatre renovated and there's still no staircase after several years, you could have an order for specific performance to get that put in. You can have an order that prevents somebody doing something. So for example, in intellectual property disputes, you might have someone taking out an injunction to stop the breach of contract of misuse of their work. Right. And if the contract is not properly performed, you may be able to sue for damages. As we talked about before, though, you might have the kind of damages of the contract not being performed actually in the contract itself, in your cancellation clause. So you rely on that cancellation clause, which is what they call liquidated damages. The terms of the contract itself show you the way to what happens if it all goes wrong. I see. So there are various things you can do. Obviously, it costs money to take anything to court. So your best bet always is to carry on talking, keep negotiating. You can negotiate your way into a contract. You can negotiate your way out. Right. You just need to know what you're bound by and how pleasant you have to be in those negotiations.
And does that apply even? Sometimes there can be something that happens that's beyond anyone's control. Whose responsibility? Yeah.
Sure. Well, there's something called frustration of contract. Okay. And this means that if the contract has not been performed through an act that is not the fault of either party, some supervening event, they say, then it's a little bit like pass the parcel, where the music stops, the contract, the agreement stops at the point at which it's broken.
Okay.
So I suppose a good example of that might be here at the Albany, someone's putting on a show, there's suddenly a massive power cut that covers the whole of Deptford, the whole of South East London. That's not the Albany's fault. It's not your theatre company's fault. What happens then is that the music stops. And if you're holding a half fee paid in advance, generously by the Albany, you get to keep it.
Okay.
If you were paid nothing advance, you can't go to the Albany and say, oh, I want my fee, please, because essentially whatever the situation is when it stops,
right,
that's how it stays. So you can't sue them for the fee, but if you're already holding it, great. It shows why it's so important to get at least half of what you're owed up front.
Absolutely, and not rely on a box office split.
Absolutely. Well, you could have an agreement on a box office split, but then within your contract you might want to have something called a force majeure, which is, sorry, it's a bit French, but it says what happens if there's frustration of contract.
Okay, I see.
So it says what happens if there's no fault ending of the contract. So yes, it's very useful to be aware of that. Obviously, people are going to be much more keen to claim that something is a frustrated contract than that it's breached, because it's a big difference in the level of liability. And I mean, thinking about your audience, I mean, obviously the Albany will have the audience waiting there, expecting to see a show for their tickets. I mean, it would be very much at the discretion of the Albany if it wanted to give them a new ticket for another night or pay them back. They're likely to do that maybe for goodwill, but there's no obligation on them to do that when the contract is frustrated. Whereas if it was down to the negligence of the technician, that would be completely different. That would be them being vicariously liable for their employees' activities.
Right.
And therefore they're in breach of contract because they haven't provided a competent technician.
I see.
Obviously, that's not the case at the Albany.
No.
It's very good.
So I'm conscious that we're coming up to the end of our 20-minute webinar. If you have any other questions throughout the day relating to contracts or any of the other topics that we're covering, please do just drop us a message, drop us an email, tweet us using the hashtag ITC99, and we will, of course, answer. Our next webinar coming up is on finance, theatre tax relief and pensions, and that's at 2 p.m. But right now, if you head over to the ITC website, we will put up the link. All related resources to contracts and negotiations are now open and available for you to look at and download. And then, yes, we'll be back at 2 p.m.
Good. Thank you.
Brilliant. Thank you very much. And